another webinar here. This is a unique webinar that we have today, and it's actually unique for an incredible reason. We're actually going to hear from two really brilliant practitioners, Andrew Stroth and Chaka Patterson, and we're going to do something very different. Before I get in, I want to make sure that everyone, if there's any issues with anyone's audio, we're going to put some instructions in the chat. Sometimes this does happen, but there's a step-by-step guide to make sure that that's correct, because we obviously want this to be something that everyone can get some benefit from. So message in the chat if there's any issues. Other than that, feel free to be engaged in the chat throughout this and ask some questions that we can dive into throughout the course of the next hour. I just want to set the table before I get these two incredible practitioners really to speak about what we're going to discuss today. So much of what we talk about when we talk about AI and the effect it's having on the legal practice right now is theoretical. We know that it's here. We know what it does. We know what it can do. We have ideas about where it's going and how it can upend and affect any sort of practice, especially the legal practice. What we're talking about today is not theoretical at all. It's a real life example of how this was tactically deployed over the course of the representation of an individual with an incredibly compelling story that led to an excellent outcome. So I am going to really be sort of honored in this. My role here is facilitator of this conversation. And I would love to start actually by just having each of you introduce yourself. Chaka, if you don't mind going first and kind of letting everyone know who you are, your background, and then how you came to sort of be involved in this case. And then after the introductions, we'll really get into the specifics of how what you ended up doing.
Sure. Thank you, Joe. So I'm Chaka Patterson. I am a partner at Steno law firm in our Chicago office. I'm an experienced trial lawyer. I've tried close to 25 jury and bench trials in state and federal court over the course of my 30-year career. I'm a graduate of Amherst College and Harvard Law School. Immediately following law school, clerked for two federal judges, Salman Oliver on the Northern District of Ohio and Karen Moore on the Sixth Circuit. I've been a partner at Jenner & Block, Jones Day, and now Steno Burge. I've also been in government. I've been chief of special litigation in the Illinois Attorney General's office, and also chief of the civil division in the Cook County State's Attorney's office. So I've had the opportunity to try cases in both private practice and in government.
That's amazing. Chaka, Andrew, are you comfortable going after that incredible resume?
Chaka's a tough act to file given his credentials. My name is Andrew Stroth. I'm a civil rights lawyer, the managing director of Action Injury Law Group, which is a national civil rights law firm that focuses on Section 1983 federal litigation, wrongful convictions, police misconduct cases. Prior to Action, I spent 20 years representing NFL players, NBA players as a sports agent attorney, and been honored and grateful to work with Chaka on the James Gibson case and to work with Steno on the game-changing technology and platform that you all have built. So thanks for having us here today, Joe.
No, it's an absolute joy. And obviously I've had a chance to get to know you both outside of this, in watching you both work and watching your minds at work on such an important issue is incredible to see firsthand and up close. Andrew, we're about to play a video that really sort of runs just a couple of minutes that sets up the story of the Gibson case. Before we play that video, do you want to add any context to how you came about this case?
Sure.
And just sort of give a little bit more color to it.
So Chaka and I, as well as a team from Lathrop, Gage, and Hart, McLaughlin, Eldridge, have been litigating the James Gibson case for the past 5 years. This video is James speaking directly to the mayor on a series called Dear Brandon, kind of just about his situation, because James spent 29 years, 4 months, and 7 days incarcerated, confined in 4 maximum security prisons. And while we all practice law, this video shows the human side of Mr. Gibson's case.
All right, wonderful. Let's let Mr. Gibson sort of speak for himself here. I'm going to play this. It runs about a minute, and then we'll come back and really get into the specifics of how you went about getting that excellent outcome you did for Mr. Gibson.
Dear Brandon, my name is James Grant Gibson. I served 29 years, 4 months, and 7 days of malicious prosecution, false imprisonment, and torture. I've been issued a certificate of innocence and exonerated. I've been awarded $200 and some thousand from the state of Illinois. So what is there to relitigate against the city now? But James Gibson did 29 years, 4 months, and 7 days. They took everything. They took everything. They tried to take my morals and my principles. This is a picture of my mama. They sent me in prison when she died, and they wouldn't allow me to go see her. Dear Brandon Johnson, take a direct course and direct action in stopping this political red tape and this madness and waste of taxpayers' money.
So, Andrew, Chaka, expand upon that a little more. I mean, obviously, what we're dealing with at the end of the day here with this case is truly a human story, and there's a whole host of supporting evidence, including that innocent certificate, to suggest that he was horribly wronged.
We want to leverage a 360-degree approach. So while Chaka and I and the team litigated in federal court, we wanted the public to know, the mayor of Chicago to know, and other stakeholders to know. So we released the video. But when it became apparent to us that the city was not going to settle this case, we went into full trial preparation mode. And that's how we were able to leverage the tools and technology of Steno to really advance this case, knowing that we were going to go to trial, or at least we thought we were going to trial, before we were able to leverage our position to get Mr. Gibson a great outcome.
Chaka, with your experience as a trial attorney, one of the things that obviously is true is that one of the strongest weapons practitioners have on either side is the willingness to go to trial and then excel and perform well at trial. That is the spot of leverage that, regardless of what side you're on, if you can do that well, then you're sort of a strong presence. What about when you were originally sizing up this case and strategizing how to run it through, what traditionally would you have done? And then how did you start to begin to incorporate the different technology into leveraging this outcome?
Yeah, so coming to this case, traditionally the way you would normally prepare once we decided that we were going to go to trial, you have to go through all the discovery. I mean, this, as Andrew said, this case, we've been litigating it for 5 years. So we had 5 years of discovery to go through, interrogatories, requests to admit, documents that were produced, deposition testimony, summary judgment, all the things that you would normally go through to prepare for trial. We had the benefit of 3 law firms to do it, but it still traditionally has been a very manually intensive process. And from time to time, because you have so many people involved, many of whom are excellent lawyers but may not be experienced trial lawyers, you sometimes, things that they may think are not important turn out to be important. Some things that they think are important turn out not to be important. And so, it ends up just being a very manually intensive process that, you have to do a lot of QA around that manual process as you're, preparing yourself for trial.
Chaka, just there's a note in the chat that your audio is kind of cutting in and out. I don't know if you want to sort of check in on that while I ask Andrew a question. Andrew, sure. when it comes to this case, if you can get specific for a second, what was one of the decisions that you made when you realized you had so much stuff to go through and you had so much, X amount of time before trial? How did you decide to take a risk and pivot to start using technology and start bringing that into the strategic process?
It became clear to us that the city was not going to put real money on the table. And so we focused in on what we would need for trial. So we identified who our key witnesses were going to be. We identified the key aspects of Mr. Gibson's case. We assessed who we thought our opponents would be putting before the jury. We assessed, what kind of jury we would be interested in. So we basically were able to put all the data and a lot of the interrogatories, and as Chaka said, the request to admit and all the filings from our partial motion for summary judgment, we were able to put all of that into the Steno platform and query specific questions. One other thing that we were able to do that Chaka and I really appreciated is what were the different themes and compelling aspects. Chaka Patterson in the beginning said, let's work backwards from the jury instructions. What will the jury be given at the end, and work backwards from that to present our case. So I think Chaka should speak to that, but that was our overall view, and it was super instructive.
And Chuck, I'd love for you to get really specific on that, because Andrew set it up nicely, and everyone's going to get to see an actual demo of how we, you really deployed this technology. But Chaka, if you could pick one or two specific examples, maybe it's the trial themes, or it was the ability to sort of outline an anticipated cross-examination, whatever it might be. If you could talk specifically about how you use technology to do something fundamentally different that you had never really done before in your practice on this case, and it turned it into a game changer, what would those examples be?
Yeah, so without question, the ability to go through all of that information that I talked about, like the depositions, the request to admit, the interrogatories, all of the statements made by Mr. Gibson, throughout, um, uh, the case and the life of the case, allowed us to take all of that information and then synthesize it very quickly through the AI tool, Transcript Genius, and really put together really strong directs and really strong crosses, come up with great themes. I mean, it really was just a game changer in terms of the quality of the output, as well as the ability to, um, just have just the quality of the output without having to worry about the too many cooks in the kitchen problem.
Yeah, wonderful. And let me sort of, as I see the poll in the chat for people who are asking if you're using AI in your firm, I'd love for people to be really thinking about this, because as we're talking about a real case here, if you have any specific questions about whether or not these two did something or had ideas about how they, you could approach it yourself, please chime in the chat. Chaka, one more follow-up on that. Let's get really specific with one example, and because I really want to showcase this here, but I want to make sure that the table is set correctly. Historically, in your practice, if you had all of the information, and there were also, this case had been up and down for I believe there were a couple of opinions issued by the Illinois Supreme Court on this case, so there was a lengthy procedural history with this case. If you had to quantify numbers-wise, let's put an arbitrary number on 500 hours of work that this normally would have taken, what percentage of time do you think you saved actually by deploying the technology the way that you did?
Oh, easily 80 to 90%. Easy.
And so,
because traditionally what we would have done is we would have parceled it out, right? So we would have said, so let's just take James's own statements. The civil rights case had been pending for 5 years. James had been in jail for nearly 30 years and had been trying to exonerate himself over a 30-year period. And so there are a number of testimony, um, public statements. He had written a draft of a book. There were all kinds of, there's literally 30 years worth of just James's statements to go through. And then you have to line them all up because, we were looking for the inconsistencies so that we would be prepared for cross-examination, perhaps motions in limine, etc. And so that work stream would have been easily a couple of months worth of work, and it would have been almost impossible for one person to do it. So you would have had to have multiple people comparing statements that James has made under oath, outside of the judicial process, over a 30-year plus period, 35 years when you include the civil rights case. And then trying to synthesize all of those inconsistent statements. What's inconsistent about them, right? And then try to put together a mock cross-examination that easily would have been a couple month process historically with a team of people doing it. And there would have been a lot of back and forth. Hey, is this really inconsistent? How might we address it, and so on? We were able to put all of that into the AI tool, and it did it in a fraction of the time. I mean, it's literally saved us hundreds, if not thousands, of hours. And not only did it synthesize all the inconsistent statements, then turned and created a cross-examination outline. It then also told us how we would address those inconsistencies, what would be the most effective way to address those inconsistencies. It did that in a matter of days. And so, I mean, it's just revolutionary in the time, not only the time saved, but the thought partnership that it also provided.
Yeah, I love that. And there's a question in the chat, Angie, about, and Thomas is asking one too, about the prompts themselves. We're going to get to that here in a second because I want people to actually see this in real time. This isn't going to be something that we've set up in advance. This is something that people can actually see how speedy it was. Andrew, before we get there though, okay, Chaka's talking about the time saving, the efficiency, the ability to do all of this stuff much more quickly. Two questions for you. One, why did you actually even think about trusting this? People are so hesitant to use AI when it comes to this, it's such a new entry into a traditional industry. That's one question. The second is, because you did and because you got the outcomes you did so quickly, how did that change the way you were able to negotiate with opposing counsel?
So first of all, Chaka and I and our team at Lathrop Gage have lived with this case for 5 years. So we know the case. And so how we became to trust is we worked with you to do the queries. And because we knew the case so well, we were able to look at the results of those queries, knowing how insightful and smart it was. Like when I think of artificial intelligence, and Chaka just said it, I think of it as a thought partner, not a thought leader. But because we were directing the queries based on information we wanted and then saw the output, we were able to trust it because we knew the case. So that's what built the trust. And then on top of that, Chaka and myself and Bill Beck and Alexander Brown, like we've got a great trial team. But I'll tell you, we had even more confidence knowing that we had this strategic outline of all the key aspects of the case that we could refine in real time. And that gave us even more ammunition to know if the city of Chicago does not want to pay Mr. Gibson a number that makes sense, that we will just go to trial. And I think the other side could feel, and they knew from the last 5 years of litigation, that we were prepared to go to trial. So it just put us in a position of strength using the Steno tools to prepare for trial. And as you know, Joe, we were prepared to have you come in as a consultant at trial to work with us in real time through that trial. So ultimately, we were able to use our confidence to get Mr. Gibson a great outcome, leveraging your tools and our work.
And Chaka, can you be honest for a second? Were you at all hesitant to add this workflow into your traditional case prep?
Extremely. I just did not have a lot of, because I had no experience with it. I just didn't have a lot of confidence that it would be helpful, and so I thought, it was going to end up adding work, not subtracting work.
I totally get it. And we hear that a lot, right? I mean, especially at Steno, when I talk about this, we hear the hesitance, and I understand it. That's the joy of this conversation. Is I'm going to start sharing my screen here. And I want people to understand now that what they're going to be seeing is in real time a actual use case of what was done on to prepare for this case. So let me set the table, right? I mean, you all talked about you've been on the case forever. There was a mountain of documents. There was such a history, whether it was statements, different filings, a whole host of pleadings. I've just arbitrarily selected a number that were living in the file, right? You see two different opinions that were issued by the the Supreme Court of Illinois. And then you've got a deposition by the plaintiff. And then we've got I just picked a motion for summary judgment here. All these documents were included and uploaded into Steno. Now, Chaka and Andrew, correct me if I'm wrong, but one of the biggest early concerns that you had, or the biggest questions that you had, were around two things. One was, look, we want to digest some of this information, and we've been so close to this case for so long as we prep for a jury trial itself. We want to get an idea of what some creative trial themes could be, and then maybe some, what kind of jurors are we looking for? What kind of questions can we ask them in association with those themes? Was that one of the primary concerns? And if so, I'm just going to, while you answer, I'm going to write a prompt to reflect that.
Yeah, I mean, I think, again, the traditional way to prepare, you got to do all this spade work first that we've been discussing, and then you start to put together your themes, and then you start to think about what your jury, your ideal juror, your ideal jury would look like. And with the ability to do all of this work, that normally would have taken months, doing it in days really freed us up to be even more strategic, with themes, with your potential juror profiles, because we were able to digest all this information in such a short amount of time. It just really freed us up to be much more strategic on those central aspects of the case, and then you know putting the themes through the AI tool to make sure that they actually matched all of the evidence that we were going to introduce at trial, and that they were the most powerful themes. And then thinking about, okay, what kind of jurors do we want, what kinds of things do we want to emphasize, and having the AI tool help us do those things as well. I mean, it really was an extraordinary and revolutionary way to prepare for trial.
Yeah. So in the time that you were answering that, Chaka, and obviously it's a critical piece of any trial prep, I asked Transcript Genius two questions. One was to synthesize all four of these documents: the motion for summary judgment, the deposition, and these different opinions, obviously, that outline the issues in the case. And I asked it to come up with 3 creative trial themes and some associated jury selection questions. And that's exactly what it did, right? Now, this is the joy of the AI, as using it the way Andrew described it, as a sort of thought partner. Is we were able to come up with a number of themes, and they're sort of lightly assessed here. There's sort of, here's some general ideas. And then based on that, we were able to kind of drill into it even more. And that was the second question I asked it. I really like the second theme. Now let's dive into that much more deeply. It comes up with a narrative arc. It gives you the associated timeline that corresponds with the theme that we selected. And then it goes into much, much, much more detail. All the time, it's citing different documents that it's pulling the information from. So to allay some of the fears that everyone should have about AI, you can verify and ensure that the output that it's giving you is correct. And if I'm not mistaken, too, here we have some just general, we came up with some real comprehensive list of jury selection questions that corresponded with those themes, so that we were as prepared as, you were able to be as prepared as you could be, knowing that you could now dive into this without worrying about as much busy work up front. Is that correct? When you got this information back as quickly as you did, was that your reaction to it?
Yeah, without question. I mean, just the ability. I mean, you literally were able to pull that together in the couple minutes we've been sitting here in real time, and that was 4 documents. So we had thousands, but proportionally we were able to do what again would take normally months with a team working on it. We were able to do in days, and it really did free us up to be much more strategic because we could continue to iterate on themes, iterate on potential questions for the jury pool, etc., and just allowed us to spend much more time on the strategy because the AI tool was going to do all the blocking and tackling and do it in minutes, rather than months.
Yeah. 100% true. And that's sort of really what I remember about this trial prep as well. And again, in the time that you were just talking, I asked it to come up based on these documents with strengths and weaknesses of my case. Again, in this case, obviously you were representing plaintiff and you were sort of filing that complaint. But this applies, I mean, this could apply to either side. And quite frankly, it does all the time. The strengths and weaknesses is sort of an agnostic question. And then I asked it to give me an opening statement outline that corresponded to the trial theme that I selected. So, in the span of, we've been talking now for about 20 minutes, 25 minutes, we've come up with at least the general structure of what a comprehensive trial notebook would look like, or a trial binder would look like as you prepare. And as you said, Chaka, it allowed you to really free your mind up to focus on the strategy, which is obviously your highest and best use case.
Yeah. Well, and there's also a strong, quality assurance component to it, right? As Andrew mentioned, because we knew the case so well, as we saw it come up with themes and come up with juror questions, we could see that the quality was extraordinarily high, and that gave us even greater confidence to rely on it more for that blocking and tackling, and what would normally have been in a traditional law firm setting, junior associates doing that work, and then partners looking it over and then trying to come up with themes, trying to come up with juror questions, with all the blocking and tackling done at a very high level, at a high quality level. It really allowed us to be much more strategic, allowed us to play around with the strategy and iterate on the strategy until we had it perfected.
Chaka, and trial prep is a unique beast, right? I mean, it's you sort of negotiate 100% of your cases, whether they're successful or not, in the negotiation side, but you try such a small percentage of the cases, and the whole process historically is one where you kind of take a deep breath and you just start going through the list of things that you have to do, deadlines you have to hit, things you have to file, pre-trial hearings you have to attend, arguments you have to make, et cetera, et cetera, et cetera. It's such a unique but sort of prized aspect of being obviously a trial lawyer. I'm just curious, right? Like what What other ways, based on this trial prep, could you envision deploying this technology outside of just a full-blown trial itself? Is there another area of your practice that happens more commonly? Motions practice, just a general hearing, anything outside of trial itself where you would find value in deploying this AI?
Oh yeah, of course. Yeah, I mean, because again, at the end of the day, once you upload all of the relevant information, whatever set of relevant information that may be, you could query it for all kinds of things. So let's say you're preparing for depositions. It's the same work, right? You need a deposition outline. This tool would be extraordinary for deposition outlines. This would be extraordinary for hearing outlines, right? So you can imagine uploading, the original motion, the response, the reply, you know, and then query the tool on the strengths, the weaknesses, what things to emphasize, what things that you can pick apart from the other side. You can even, right, you can ask it to put together a series of, what are the hardest questions that I should expect to face, and what might be some good responses to those hard questions, right? So there's all kinds of things you can do in sort of ordinary everyday litigation practice with this tool, totally separate and apart from trial.
Yeah, that's a great one. Actually, it's churning out an answer. As you mentioned that in your answer, I asked it that very question, just presuming a whole different set of procedural facts. Here's the same set of 4 documents, but in this case, I'm prepping for a deposition. I've identified which side I'm on. Give me an outline. So I think that that's a really brilliant use case. And I'm going to sort of ask it that follow-up question now about difficult questions I anticipate this witness getting and good answers so that I can use it to prep the witness in advance of the deposition. One of the things that I also think while I'm getting that prompt ready and I want people to actually see it, Chaka, was there anything, one of the fears that people have around AI usage is that it's such a new entrant to the field. Obviously, there's security concerns and there's sort of output concerns. Is it telling me the right thing? But then there's the concern of what does this mean for my job? Right? What does this mean for the future of the practice of in the legal industry? My sense of how you're answering this question is that all this does is supplement you and allow you to do the thing that you are best equipped to do, which is strategize and plot. Is that correct? Did this give you was there anything that this did that made you afraid to use it again?
Oh no, not at all. I think this is literally a game changer for litigators in particular. I mean, it really does free you up from the blocking and tackling to be much more strategic. And it the tool can also act as a thought partner. So I think this is so whether you are in a big practice setting, like where I practice, you could put your associates to work doing much more strategic stuff than because the tool will do the blocking and tackling. If you're, the smaller your shop, or the smaller, like I've practiced in the government, like I wish I'd had this tool in the government, right? It would have allowed me to work so much more efficiently and impactfully, right, going up against the big firms like mine, where they can throw 50, 60 people at it. You can't do that in the government. So if you're in the government, if you are in a high volume shop, if you are in a small law firm, this tool really becomes indispensable in freeing you up to do more of the fun stuff, which is the strategic stuff, and because the tool will do the blocking and tackling, and it can also help you with the strategic stuff as a thought partner.
Yeah, that's wonderful. That makes a lot of sense, and that's been my experience in using it as well. And I asked it again. Use your question, give me an anticipated cross-examination outline and some good answers. I'm gonna keep peppering this with different prompts because I want people to see in real time how quickly you can get the answer. When I was doing appellate and post-conviction work in a prior life, these single assignments would take days or weeks to accomplish, and the fact that they're getting answered in the span of a question that Chaka is answering live is always something that's impressive to me. Let me pause real quick, Chaka and Andrew, while I just there's a couple of questions in this chat that I really want to sort of address here. And one of them is how we went about developing the AI prompts in order to get the results that we were looking for. To tackle that one head on, two things that I always say. One is that the hesitance to use AI very often pivots around that question. How do we ensure that the quality of the AI and what it tells us is as high? How are we getting the right information? And I want to say to that point that AI is getting better at guiding you to the information that you want. But you sort of have to be fearless to just step in and give it the guidance that you would someone who stepped into your office and you were giving an assignment to. We've got a trial coming up in a month. Here are the documents that I want you to examine. They're all very different. Here's what I'm looking for: a set of inconsistencies that exist across all these documents. Now go ahead and create an outline that I can use to prepare this witness for the cross-examination during trial. So as specific as direction as you would give someone real time in your office is what we did to develop these prompts. And then we're fearless about following up. So if you see something here, for example, a line of questioning specifically about police misconduct, and you only see 3 questions, then you have the power and the ability to just jump back down here and ask for, give me 30 questions about police conduct. And it's going to, in real time, go right back to this issue that it spotted and dive much more deeply into it. So there's a fearlessness about re-engaging with the AI. Another question that came up here is because Transcript Genius doesn't say the chats, did they copy and paste into Word docs or did they do something else? That's exactly right. I mean, I think that the power of what Chaka and Andrew were doing was custom building based on their experience and based on the way that they were strategizing this case, a trial prep binder, something that contained within it all the information that they were using to set this case up for success. And in this case, a heavy part of it focused on anticipated cross-examination or jury selection questions that corresponded with trial themes. And the ability to just take it out of Transcript Genius and put it in whatever document that you're using does 2 things at once. One, it preserves and obviously allows you to custom build whatever you're trying to custom build. But secondarily, it can reassure you that when you close out of this interrogation, from a security perspective, this is over with. There's no retention. There's no AI getting smarter based off this information that you're putting into it, which is obviously a key part of the ethical use of AI for practitioners now in the current state of how AI is being deployed. So those are both great questions. If I didn't answer,
and I would just, I would add, another thing that's really extraordinary about it, right, is, you could take a snippet of a deposition where, you really hammered a witness and, they got flustered or whatever the case may be, right? Load that in. So when you're doing your cross, load that in to the AI tool. And so when you're asking the AI tool to create cross-examination questions, you can ask it to mimic, right, the style of the deposition where you really got the witness flustered or you really pinned them down so that you can basically recreate that moment at trial. And so, the tool can do things that would be harder, I think, for young lawyers or lawyers not as experienced with trial work to to recreate. And so that's part of the fun of the iterating and being strategic, and using the tool as a as a thought partner, to help you create these, and obviously the opposite side of the coin, your witness got pinned down or got flustered or whatever, and so you could create some practice, cross for your witness, and help them, kind of work through where they got pinned down or flustered in a deposition. So it's just it's just amazing how much you can really use the tool to help you prepare for various stages of the litigation.
Yeah, I love that, and I asked it again. I mean, I keep saying the same thing, but it always does impress me. I asked it again in the time that you were sort of answering your question, Chaka, based on those 4 documents to give me a comprehensive timeline of events, and I wanted it in a specific format. Now, this goes back to a different use case, and I've copied and pasted it so that people can see how easy it is to take information right outside of the AI itself and put it in a document. But the format is nice and clean, and it's really synthesized a number of really important documents and put it in this. Now we're just slowly building and building. And I think over the course of a couple hours on a Sunday, we basically put together the entire structure of 150, 120 page cross-examination outline for this witness. I guess the point is the limit is your imagination, right? I mean, you can upload the documents, you can put whatever documents that make sense and that obviously Transcript Genius can handle into a query so that you can do everything that you've just said for the last 30 minutes. Let me pause really quickly, Chaka, if you don't mind. There's another couple questions in here that I want to answer. Someone asked the AI model that Transcript Genius uses, and that's ChatGPT, Claude, or anything else. We use Claude, and we use the most recent version of Claude, and that they just came out with a 4.1 that we test internally. We make sure that we run it through all the tests that are really specific to the functionality of this tool, so that the output of the product itself is verifiable. We understand it understands, and it's tailored to the use of a practitioner. Plaintiff's counsel, defense counsel, it doesn't matter. You can deploy it as effectively on either side. And it's really geared for what you're seeing it to do here. There's a lot of generalist tools out here. Our internal team has taken the power of those tools, added a whole bunch of background prompting and information and guidance so that it knows exactly how to deliver what you're looking for in a way that is verifiable, so that you don't have to worry about, you do have to double check where the information is coming from, but you don't have to sort of in a cumbersome way double check the output and verify exactly what it's telling you, because you can just click those verifications like right here. You can see that it's drawing it directly from this part of the direct examination itself, which is a really powerful use case and a really important part of using AI now. As well. So I hope that answers that question, but that's what Transcript Genius uses. One other question that I want to answer before I get back to you, Chaka and Andrew. I know Andrew's, I think, popping in and out, maybe some internet issues. Getting the documents into the system is super easy. I'm just going to show you actually how to do that very, very easily. When you go into your, well, I'm going to have to sort of log back in, but I'm going to show you how to do that here in a second when I go back to the top here. It's simple. You can do it so easily. If you go into Transcript Genius and you want to upload your transcripts, you click the upload transcript. You can see that text files are uploadable. We also can handle PDFs. All you do is select them from your computer, and then within seconds, they're available to be interrogated by this information. You can upload quite a few at once. Depending on if they're text files or PDFs, it takes a moment longer to process PDFs, but it is very, very, very easy to to add those in and interrogate those. Chaka, let me get back to you here for a second. Thinking ahead now, the purpose of you being plaintiff's counsel on a case like this is obviously delivering a result for your client, correct? I mean, is that how you view your purpose on this case? It sounds very fundamental, But what did this do financially? What did this do from a cost saving perspective for you that allowed, let's say, you obviously we talked about the efficiency of this, but now quantify this for Mr. Gibson. I mean, it sounds like with the money that you saved, obviously, mathematically, it would make sense that a great deal of more money and probably wound up in his pockets at the end. Is that correct? Would you agree with that assessment?
Yeah, what I would say is, for this particular case, we were, pro bono counsel, but, Andrew and I have had a lot of discussion, that, this is, an extraordinary, cost saving tool. What I did not mention in my background is that I was also general counsel of Adtalem Global Education for several years, um, and head of litigation at Exelon Corporation for several years. And so I know from a client perspective that this tool could be provide enormous cost savings for clients, particularly where clients have repeat litigation, where clients have big complex litigation with lots of documents, and you don't really need an army of associates anymore, doing the blocking and tackling. Right now, all of your lawyers will be empowered to be strategic thinkers, which itself will generate a lot of cost savings, because not only is the blocking and tackling done by the tool, but you're getting a higher quality and a higher value for each dollar spent with outside counsel.
Right. I mean, that makes a great deal of sense. I very much that seemed to play out, right? Again, we're not talking abstractly. We're talking about this has proven itself. And a couple of questions that also popped up here is what kind of we use Claude Sonnet or Opus. We've done testing internally on both of those. We use them both for different reasons and deploy them based on single or multi-transcript interrogations. So that is a great question. There are AI limitations, Angie, on the number of transcripts that can be interrogated at once. It's purely because, the quality of the output, as you're hearing from Chaka and Andrew earlier, is the thing that matters the most. If you can rely on this to do something responsibly and thoroughly over the course of an interrogation, that matters much more than if you can put 100 transcripts and get unreliable results. AI, as it continues to evolve, is expanding the amount of context it can sort of digest at once and deliver accurate results on. But until then, and as that slowly increases, the priority, especially on our side, I'm a lawyer myself, right? I practice myself. Quality and verifiability mattered tremendously to me, and it mattered so much in this case as well. Chaka, let me ask you, let me go back to this. I'm still sharing my screen here, and I've got any other, some documents that I've selected. But I'm now kind of wondering, given the success of how this was deployed on this case, how did it make you consider other cases that you're working on? And did you start thinking more creatively about use cases for the AI itself down the road?
Oh yeah, without question, because again, so for example, I do a lot of internal investigations, and corporate internal investigations for corporate clients, employee malfeasance, accounting and financial issues, etc. And the ability to um, you know, upload information, um, to synthesize, what kinds of questions should we be asking witnesses? What kinds of things should we be thinking about? What kinds of documents should we be requesting? Taking all the emails from a particular witness and doing, right, it's the same thing. Okay, digest all these emails and let's think about, what are the consistencies? Where are the inconsistencies? Creating timelines, all those things have created tremendous value, and I'm able to do a lot of that myself, which then saves the client a lot of money. And so now, when I bring in associate help, it's really at the strategic level. Hey, let's think through how we want to approach this witness. Let's think about what how we're going to get the information we want to get out of this witness, right? So it's much more of a strategic interaction with my colleagues than, hey, go off and read these 300 emails and tell me where they're inconsistent.
Yeah. And again, Chaka, when you were talking, it triggered something we hadn't really talked about, which was just how strongly this could participate in a healthy motions practice. I just asked it to sort of query these documents again, with the idea that it's going to be sort of scraping them for motions in limine. And
Right.
I don't know if what you can see on the screen here, but this was part of, I think, the trial prep as well, was just using it as, again, a thought partner to see whether or not it can assist in what can be a pretty time-intensive process. Now, the joy of this too is if I ask it to, put this in a format I can copy and paste into a motion, it allows you to really, really, really tweak the format of the output so that you can make it a little bit more actionable. Anyway, Chaka, as we're kind of closing in here on the top of or I guess the bottom of the hour, whatever it is, the end of our time together, I know Andrew's having some internet connection issues. Give me some sort of closing thoughts. Give me some sort of last ideas. And I really would love them couched in this way. So often, I was just in court this morning, and so often in this world, we can get lost in the minutia of what we're doing as practitioners, like the black and white, the paper, the review, the filings, the deadlines. And at the end of the day, what we're all doing is dealing with someone's story, and making sure that what we're doing is grounded in sort of getting value for someone or standing up for someone, regardless of the adversity that they're dealing with. Was it really surprising to you at the end of the process how kind of rewarding it was to actually use the AI for the purpose that you used it? It looks like we might have a couple of internet connection issues. So I'm going to sit here and sort of answer that question, I think, for Chaka and for Andrew right now, which is, after this case resolved, we really talked, we were able to reflect on the tangible ability, the tangible effect that this had on a human life, and the power that this brought to actually prepping it thoroughly and strongly for this case. And I think what came of it is, what you can see is that it really allowed for the legal process to work in a way that I quite frankly hadn't seen it work as efficiently before, because of all we were able to accomplish in such a short period of time and done so well. So this is a lot of content, everyone. To everyone who was asking questions, I really appreciate it. There were a couple of questions that people were answering in the chat about how quickly information could be uploaded. As soon as the deposition is booked with Steno, you have access to upload your information to prep for your deposition. As soon as these transcripts come back, because you booked a job with Steno, you have the ability to then use the Transcript Genius. I mean, it's a crazy thing to say at the back end of the hour. Everything that you just saw Transcript Genius do did not cost a cent. If you've booked a job through Steno, you have access to this technology in an unlimited fashion. So what we did over the course of the hour, demonstrably, was build the beginnings of a really thorough trial notebook based on a tremendous amount of documentation. That's not costing you anything. That's one of the things that I think we prioritize at Steno, is this ability to make sure that all the technology is really thoughtful to benefit your practice, and it engages with each other so well and thoughtfully. So you're just seeing, I think, a real-time example of how this technology was deployed fruitfully and beneficially for the positive outcome of a person whose story you saw at the beginning is pretty harrowing. I've been talking for probably way too long. And Chaka, you're still here. I want to say thank you for your time. We've still got 4 minutes. So if
Yeah, my
anyone,
pleasure.
yeah, really appreciate it. And if anyone has any questions specifically that haven't been asked yet, feel free to pop them in the chat. I'm going to pop my email in the chat because one of the joys of having a law license is being able to use technology like this for good. And I would love to be able to assist with anyone if they have any additional questions about cases they might be working on or ways that Steno can be leveraged. I'd be more than happy to be of value to y'all. So much appreciated for everyone's time and attention and engagement over the last hour. And I'll hang around for another minute in case any other questions pop up. But thank you again, Chaka, for everything.
Hey, my pleasure. Let me, I'll just close out by saying that, being able to leverage this technology on behalf of a wrongfully convicted person like Mr. Gibson, who spent 30 horrible years confined in horrible situation, and to be able to get him a modicum of justice, and to be able to leverage AI to position ourselves to do that. We went into the negotiations with an extraordinary amount of confidence because we were able to do so much in such a short amount of time, leveraging Transcript Genius. I mean, it really was a blessing for our team and ultimately for Mr. Gibson. So, honestly, Joe, we can't thank you and Steno enough for your help in empowering us to help Mr. Gibson.
Well, it was a true honor, and it was a great combination of wonderful legal minds on your end with technology just that made this whole thing work the way that it should. So I really appreciate it, Chaka. Thank you again.
Yeah, absolutely.
And I'm staying. Angie, you asked a question. Dio gave you the answer, but if it is, PDFs are actually a brilliant feature of Transcript Genius now. So get in touch with your rep if you have one. Otherwise, feel free to also reach out to me. We'll make sure that we get it enabled for your account. And there's one other question that was asked. Oh, John asked a similar question. Does it have to be a text file or can it be a PDF? John, it can be both. Do the same thing that we just advised Angie to do. Get in touch with your rep. Get in touch with me if you'd like, and we'll make sure that that gets enabled for you. I can tell you that the way our team built the PDF searchability, and it's fantastic, and you're really going to see value on that front too. So get in touch with me or your rep, and we'll make sure that it gets enabled for you. I think that is all the questions that I see people asked and answered. And I think you're going to see on the screen now, AI and Legal Practice Guide. Feel free to download this. This gives you some insight into how Steno thinks about AI, how we've used AI, built our AI tool, how we sort of begin to suggest you use it. And if you have any further questions, please, please, please don't hesitate to reach out. That matters so much to us, and we sort of love being as hands-on as we can as you continue using Steno and all the things that we offer. So with that, thank you so much for joining over the last hour, and we will until next time.